staying there. The man is violating, their rights to a peaceful neighborhood, and they just won't bother coming to court. So the issue is there something about how people perceive you that they just don't feel they should even bring it to you? And that's why some will just lynch others and all sort of things.
Thank you, Mr. Chairman. I'm happy you use the word perception, that people perceive that if they approach the courts, they will not get redress. But I think that is a very, very unfortunate perception. Listen, when I was in practice, I practiced for more than 30 years before I joined the bench. I had situations where people will come to me with their problems, and they say that this person owes me this amount of money. But even if I take it to court, the court will say, go and come, go and come, go and come. And then it is then left for me to educate the person, sit him down, and teach him that that is not true. We can go to court and we can get your money. And if you like, because I have confidence in what I'm saying, I will not charge you anything upfront. So I used to do a lot of cases where I don't even charge upfront. I can decide not to charge you upfront. When I have recovered the money, then you pay me a percentage. And then we will go to court, and then within the time that I promised him, we are able to get a remedy. He comes back to my office, and he says, oh, lawyer, I am so sorry I had this preconception. I was being misled by so and so and so and so. So I think that at the end of the day, the main issue that fuels this perception is lack of education or lack of transparency. But I think the judiciary now is seriously...
Or actual experience of the judiciary.
No, I don't.
Or actual experience.
I think that the judiciary is now, with our current head, is now seriously addressing that issue. We are now, as it were, opening up a little and giving ourselves a place in that space. We shouldn't make any representation. I was watching a program, I think 2 weeks ago, where one of our best orators as a judge, a Supreme Court judge, was on TV, opening up some of the things we did as judges. And for that 1 hour period that I sat behind the television, I fell in love with the judiciary. Even though I simply fell in love with the judiciary. Because what happened was he opened up certain things that otherwise nobody would have known. So with this gradual opening up, I think that it will get to a point where some of these perceptions will be totally addressed. And I think it's a very good practice that has been started now. And if I have the opportunity, I would urge that it be continued and it be expanded and maybe throughout the country, wherever we get the opportunity to. Because you see, in this moment of internet and social media, where news can just fly across without any limitation, if you don't also occupy a space, you'll be surprised things that can be said against you and you will not have an opportunity to clarify. So with these things, my hope is that a lot of the perceptions that have saddled the judiciary over the years will now be a thing of the past. And that is my sincere hope. Thank you, Mr. Chairman.
Thank you very much, Mr. Chairman. Thank you very much. My Lord, congratulations.
Thank you, Honorable Member.
My Lord, on page 6 of your CV, June 1995, your LLM thesis, the Himalaya Clause and Section 8.2 of the Contract Act of Ghana. Lord, can you educate this committee and the public what Himalaya Clause is? And I have a follow-up question on that.
Thank you, Mr. Chairman. The Himalaya Clause is a very popular clause that is usually incorporated in a contract of carriage of sea, maybe a charter party. And the essence of that clause, it is actually an exclusionary clause that is designed to exclude liability for the ship owner and his agents. Now, the traditional notion of shipping was that the ship owner was the only person who could enjoy the benefit of exclusionary and limitation clauses in the contract of carriage, based on the principle of privity of contract. So it got to a time where ship owners were employing private stevedores to also play a part in stevedoring cargo from the vessel. And because they were not actually part of the ship owner's employment, questions were raised that if they are not part of the ship owner, under what circumstances, based on the doctrine of privity of contract, can they purport, being third parties, can they purport to enjoy exclusionary clauses, the benefit of exclusionary clauses in a contract of carriage? So the Himalaya clause was introduced to extend the purview of these exclusionary clauses to benefit third parties who are not part of the regime of the ship owner. For example, a vessel comes to Tema and they engage a private company to conduct stevedoring operations from the vessel. There is damage to the goods. Can the private company claim to be entitled to the same benefits that the ship owner is benefiting under the contract of affreightment? Initially, traditionally, the answer was no. But this Himalaya clause was then developed out to bring these third parties into the regime of benefiting from the exclusionary and limitation clauses. Now, the problem still remained that the courts were not too comfortable. Common law is a very, very conventional tradition. It was not too comfortable with this. So cases were coming up where they were trying to strike down the Himalaya clause. So when I had the opportunity to do this research, we had in our Contracts Act, Section 8.2, which gave the opportunity for third parties in contracts to enjoy the benefits of the contract. So I looked at the two regimes and then drew parities between the two regimes and arrived at a conclusion. So that essentially was the subject matter of this thesis program. Thank you.
Thank you very much, my Lord. So more or less is kind of an indemnity of sorts for those third parties. But I see it as a shield. But can it be used as a sword as well? If you can't be more or less, if you are indemnified, can you, in like terms, also be able to found an action against, third parties?
Thank you, Mr. Chairman. I cannot envisage a situation that you can use. As you rightly pointed out, it's a shield that protects you from liability in respect of certain claims, where you can rely on the limitations and exclusions that are available to the ship owner. But I have not come across a situation where you can use it as a sword to found a cause of action against a third party. I have not come across any such situation. Thank you.
Thank you, my Lord. Mr. Chairman, I recall recently a High Court granted an injunction on the performance of the final funeral rites of the Gamanye. A day after or is it same day, the injunction was vacated by the same judge. Now, I want to believe, and I believe the entirety of Ghanaians believe very strongly, that because of the personality involved, that was why the order was vacated almost immediately. Now, we have instances where lesser mortals, like Sosu and I, probably have gone through such situations. And because of who they are, they don't have a voice, they don't have gravitas, they don't have presence. And so some of these things just, are just, washed more or less under the carpet. Is there a situation where some orientation can be, given to the general public? More or less a public education about some of these nuances. So it doesn't create an impression that because of this person, justice can be tilted in a certain direction. But that was the impression that a lot of people got. I don't know whether you agree with me in that respect. Thank you.
Thank you, Mr. Chairman. I am not actually privy to the peculiar circumstances of this particular case and the circumstances that informed the decision of a trial judge to vacate the injunction. But what I can say is that every application for an injunction is determined based on its own peculiar facts. There are some broad general principles that should guide the courts in either granting or refusing an application. But the fact that you can apply principle A to these facts doesn't mean that you can apply the same principle to another set of facts. It's a matter of discretion. An injunction being an equitable remedy is a matter of discretion. And we all know what a discretion means. So I really don't know what informed the decision of a trial court to vacate the injunction a day after. But I am aware of a Supreme Court decision. I didn't know I would ask this question, otherwise I would have brought it. I think I used it in Kumasi. That tried to suggest that as a matter, I think it was, if I'm not mistaken, the former Chief Justice Wood, CJ, who articulated that principle, that as a matter of public policy, we must be very careful in granting injunctions that will result in deceased members of family being unduly kept without being accorded their lawful rights. So if this policy consideration is behind the mind of any judge, I think that he will know how to proceed. Thank you, Mr. Chairman.
Four questions. Thank you. My Lord, I wish you well.
Thank you, Honorable Member.
What has happened to my microphone? Please come and check that for me. Gisela, yes, yes.
Thank you very much, Mr. Chairman. Congratulations.
Thank you, Honorable Member.
To you, Justice Yao Dakwasari. In your 30 years, as you yourself mentioned, of law practice, and from your CV, 4 years at the Appeals Court, what advice would you give the Chief Justice on specific or general improvements in the entire judicial system?
Thank you, Honorable Member. I think that the essence of the question is asking me to suggest maybe judicial reforms that will enhance the dispensation of administration of justice, if I understand you correctly. I think one area that I would quickly mention is in the area of using practice directions and manuals. I was very fortunate to have been, I don't know whether I can mention it, but I borrowed a practice manual from the English courts, the financial division, from the Chief Justice to acquaint myself with the way they do things. That manual is about this thick, only for the commercial courts, about this thick. And when I read it, I was amazed because it's like every step that you take in the commercial court is set down in black and white. And if you have this in Ghana, and the judges know that if this step I take, this is the next step I'll take, this is the next step I'll take, this is the next step I'll take, it will expedite the administration of justice in a way that I cannot imagine. So I am happy that the Chief Justice that we have now is a consummate advocate of the use of practice manuals. And if I don't think I can advise her on this, because she rather advised me by giving me a book on that. So if I have to offer any other advice to the judiciary, another general area that I would want to really start a conversation on is the use of, not ADR like in the wider sense. ADR in the wider sense is good. It's a very beneficial thing. But in the area of case management, where we can use pre-trial settlement conferences, we make it mandatory for every case that appears before the court. They must go through these pre-trial conferences and explore the means of amicably settling suits before they lead up to trial. Because from the studies that I have seen, I think that about 90% of cases that go to trial in Ghana are capable of being settled amicably. I think that the problem is how to really sit down and train people and reorient the minds of litigants. Because we have a tradition. I am an Achim, and we say that as for the Achims, they love litigation. We have a tradition where an Achim man will sell all his property to litigate. Not because sometimes the subject matter, but the fact that he wants to show the opponent where power lies. So if we don't reorient our minds about some of these things, so that dovetails into my concern for training, education, transparency, and all those other things. When we do these things, I think that will push the administration of justice. But already I must confess that the judiciary is doing a lot in the area of e-justice, in the area of changing rules of court in order to make them more practicable, more expeditious, especially also in the area of execution of judgments. The judiciary is doing a lot in that area. And it's an area that I think that we can all start a conversation on and really push it, especially in the area of execution of judgments. A very good friend of mine, maybe I should just say this called me the other time, and then he was lamenting about what happened to that. We used to have a remedy called summons to show cause, where you owe money to a judgment creditor, you don't pay, the next day you are there. And because of fear of being put, people were just paying left and right. But we are now in a constitutional era. That this thing was struck out. But a lot of people are saying or asking, can we bring it back? I tell them maybe we'll have a problem because of the constitutional implications. But because now you take judgment even against a company.
My Lord, yes. Are you suggesting that the Constitution frowns on imprisoning your debtor?
No, I think that the decisions that that reverse that practice, Badamosi and Muhammadu and all those line of decisions, I think that Iba explained why in this constitutional era we could not continue to have that practice. But for practical purposes, like I'm saying, a lot of people think that even for companies, you could even attach the directors those times. But I'm not advocating for it. It's not something, for record, I'm not advocating. I'm just saying that it was something that was done in the past. I think that, thank you.
That's very interesting, because people will deliberately refuse to pay their debts and frustrate you. And it's only the fear of being detained or imprisoned. So we should redefine the rules to suit our purposes. Our peculiar culture of generally not paying our debts unless we are brought under some pressure. But this is just a comment.
Thank you, Honorable Chair.
Thank you. That's quite an education we've had here. In the vetting of the previous nominee, we generally discussed, I don't know if you were privy to that, but we discussed how almost every case kind of seems to have to end up at the Supreme Court. Do you think, again, as referring to your practice as a lawyer of 30 years and your 4 years on the bench in the appeals court, do you think that perhaps there's not enough confidence in the lower courts that everything seems to have to end up at the Supreme Court? And if so, or otherwise, what do you think can be done at every layer so that at every layer there can be termination points for certain cases that it doesn't need to go beyond this to the Supreme Court?
Thank you, Honorable Chair. I think that the answer to this question can be traced to the fact that the citizens have become more enlightened in terms of the enforcement of their rights. And he knows that even if he loses at the district court, he has a right of appeal to the High Court. He has a right of appeal to the Court of Appeal. With leave, he can even proceed to the Supreme Court. And I think that the framers of the Constitution probably had some legitimacy in ensuring that the doors to the Supreme Court were not, as it were, clogged by ensuring that if you have the desire, you can proceed right up to the Apex Court for the Apex Court to hear your case. He thought that it was a right that should be available to every citizen. And there are statistics which seem to suggest that this may not be a bad idea, because sometimes you lose at the High Court, you lose at the Court of Appeal, but when you get to the Supreme Court, you win. So what if the structure was that you could only end at the Court of Appeal? It means that even though you had a meritorious case, you would have lost. But having said that, the system is open to abuse. The fact that you open the door wide to the Supreme Court, it is open to abuse. And there are some lawyers who know for a fact that their cases are bad. They know that their cases are bad, but they will still want to push it to the Supreme Court because the door has been opened. So my answer to your question is that whilst not opening it too wide, we can put some clocks, maybe not too many clocks, but some clocks in the way, so that the Supreme Court is not unduly swarmed with frivolous cases. Mm-hmm. I can imagine a situation where interlocutory appeals can be made to end at the Court of Appeal. I can imagine a situation where appeals as of right will not be the thing of the day again, that you may need to go through some form of leave. And I can also imagine a situation where, I think I read a judgment delivered by Duce, one of his last judgments that he left, and was referring to Section 34 of the Courts Act, and was saying that there must be a mechanism by which we can filter frivolous cases from coming up for hearing. I think that if we started a conversation in that direction and see how far we can go with that suggestion, because coming from Duce and a lot of the other judges, even though it may not be quite a straightforward mechanism, but at least we can start somewhere and see where it goes. Where we can have an administrative mechanism, maybe one or two Supreme Court judges can sit down and then look at a case. A case has been maybe the principle of law has been determined about 100 times. There's no dispute about it. The facts are far from complex. Why should they come up for hearing? The parties will come, they have to come and file, and taking into account the number of cases that we have at the Supreme Court now. It's incredible when you hear the numbers. So if we have a filtering system like that, maybe it will be of some help to the administration of justice. Thank you.
Thank you, Mr. Chair. Sorry, my last question.
Yes.
How do you give back to society?
Thank you very much, Honorable Chair. I give back to society in numerous ways. Even becoming a judge is one of the ways I thought I should be giving back to society, because I left a practice that I will not say that I was the most this thing, but I believe Honorable knows what we were doing in Tema, And so leaving that and then coming to the bench with an idea that I was coming to serve. Mm-hmm.
All right.
Thank you, Mr. Chair.
Honorable Jogate will ask a question and leave.
Mr. Chairman, thank you very much. First of all, I hear you saying that you have practiced for 4 years, you've been a judge 30 years, 34 years. But I know that I'm 35 years at the bar, you are my classmate, so I'm wondering why you've reduced it by a year. Whether I'm wrong or you are wrong.
You delayed. Maybe I think I about my maths, to be honest. My maths is one of my worst. When it comes to calculations, I don't trust myself at all.
I'm told that you have a lot of friends here. There are a lot of lawyers here who have a similar problem to yours. But well, one of them said he had O-level 9 in maths. I won't mention his name, but he's sitting quite close to me.
To your right.
No, I will please. Honorable members, now there's a lot of denial, so it was just a joke. Every lawyer here got 1 in maths. But Mr. Chairman and my Lord, you know, the Methodist hymn 832, it says in its 4th stanza that, "O blessed communion, fellowship divine, we freely struggle and they in glory shine. Yet all are one in thee and all are thine. Alleluia, alleluia." Now, when we went into the faculty many years ago, you were part of the people who were in glory shining. Dampari, his brother, of blessed memory. Then somebody like Atiobi Danso, someone like Prempek, Betty, and so on, and yourself. You were the people who were shining. We were feebly struggling and following you. And in those days, by the time we got to the 3rd year, we were only 60. And a few people added, Honorable John Debugui of blessed memory and so on. DQC added. So the whole class was about 65. And we're like a family. But out of this class of 65 people, 2 became Attorney General. And you are going to be the second person to become a Supreme Court judge. Now, the first I became Attorney General. Years after me, Ben Kubo became Attorney General. And Honorable Kwama, whose name was also among those who were shining, we used to call him Scott J, is now in the Supreme Court, and he's also going to join. You know, I'm not a boastful type. Neither am I arrogant. But I remember reading in Things Fall Apart that the lizard which fell off the high Iroko tree said he would praise himself if no one praised him. And that's why when lizards fall down, they nod their heads up and down. Please praise yourself and praise me as well. The class of 88. I challenge any other law class. I am saying without fear of contradiction that we are the best class ever in the law school. There's another one where please, you know, just because he's chairman, he wants to speak. He knows that my class is better than his. His class is 89. But anyway,
all I'm saying is that this is a self-pronouncement. It's not part of the proceedings. It's not an edict of the appointments committee, please.
I would have been surprised. You see, what is happening here, unfortunately, is a classical case of jealousy. Other members from other year groups are saying it's not true and so on. They should bring their evidence. But, Mr. Chairman, I'm also happy that you've been appointed because of your expertise in the area of maritime law. Would you think that I can turn anything to a question? Don't forget that I've practiced for 35 years. Don't forget that I'm quite an experienced lawyer. So would you agree with me that as a maritime lawyer, your expertise will be useful to the Supreme Court?
Thank you, Mr. Chairman. Yes, I will wholeheartedly agree with you. Thank you.
That congratulations, and that to be all.
Thank you very much.
Okay. Please, another senior member. So he's a ranking member of the Judiciary Committee, and I invited him to come and join us. So give him the permission to ask a question.
Yes. Yes, 1993. I was the first chairman of. Chairman, thank you so much for the opportunity. I just want to set the record straight. I just want to set the record straight. My honorable colleague, Honorable Joe Gatti, claims that he had 2 of his colleagues in the Supreme Court and 2 Attorney Generals. 1978 call. I'm 45 years at the bar. He's 35. I'm 10 years ahead of him. And we have a record. The 1978 year group have a record of more colleagues in the Supreme Court than your group. Let me mention them. Jones Doche, who has just gone on retirement. Julius Ansah, who has also gone on retirement. Professor Kote, who has gone on retirement. And then Ayirbi something. Yes. We are the champion. You can't.
But Mr. Speaker, then come to Attorney General. Come to Attorney General.
There are many. All I can mention. Martin Amidou. Martin Amidou is my classmate. 1978 year call. And no, Kumboy is far away behind. And myself, beyond Attorney General. Yes. Mr. Chairman, I've organized, I've been in charge of 4 ministries before. Lands and Forestry, Environment, Science and Technology, Interior, Regional Minister, Majority Leader, and Wise Man. How can he be able to challenge me? Dare you challenge me? You can't challenge me.
Even before Chairman pronounces, I admit.
Yes.
I admit.
No. Honorable members, the matter is settled. Once we go to the wise man, there's no competition. Yes. You spoke. Okay, so first. I'll come to you.
Yeah, thank you very much, Mr. Chairman. Congratulations once more, Your Lordship.
Thank you.
Your Lordship, I realized that from the CV, your religion was indicated as Christianity. I'm just a little bit curious about like which church or denomination you worship with.
I'm a member of ICGC Calvary Temple.
My Lord, as a quick follow-up, there is, I have observed generally that the Ghanaian community is extremely religious, but sometimes you are not godly because the values of godliness, the fear of God, honesty, sometimes are missing. My Lord, with the greatest of respect, as a Supreme Court judge, if your religious beliefs come in conflict with enforcement of some rights as guaranteed by the Constitution, which one would you defer to?
Thank you, Mr. Chairman. I believe that if I'm given the nod with your kind approval, I'll be made to swear an oath. And that oath will be to administer justice to all manner of persons without fear or favor, affection, or ill will. I think that with that oath that I swear, which I believe that is an oath that I've sworn to my God, I will be bound to administer justice when I'm in the courtroom. I will not be administering religion or faith. So I would seek to be bound by the law, and so bound. Thank you.
Lordship, Mr. Chairman, what would you consider to be your legal philosophy or your dominant legal philosophy? Are you a naturalist, a positivist, or a realist? What would you consider to be your dominant philosophy? And how would that be helpful to the Supreme Court once you are given the nod?
Thank you, Mr. Chairman. We learned a lot about philosophies whilst we were in law school, but I don't think that I'll consider myself a slave to any of the philosophies, even though I can be a disciple of some of them. I think that my main philosophy will be a sense of fidelity to the Constitution that I have sworn an oath to, and to ensure that if I am administering justice, at the end of the day, there will not be a manifest failure of justice. Because if I want to adopt a certain philosophy, and in the end, there is a failure of justice, I would think that I would have left me, myself, down. So I don't think that I would adhere to any other philosophy apart from ensuring that my fidelity to the Constitution, to the principles of the rule of law, and to ensuring that there's no failure of justice under my watch will be my guiding principles. Thank you.
My Lord, Mr. Chairman, there is also this general perception that many Ghanaians conflict petty gifts with bribery. And I'm asking this because, for example, when you take our media men, anytime they cover, they are looking for what they call soli. Sometimes you go to court, if there is no facilitation, court bailiffs will not run around to quickly set processes, and they are in a hurry to set processes of those where there are more facilitation than others. You go to other institutions, like all kinds of things happening within our context. There's some, I don't know whether it's a cultural thing or what it is that we are losing out on, whether it's indeed gift that has turned into bribery. What is your perception about, or what is your view about corruption generally in Ghana, particularly in recent time when even the special prosecutor, Mr. Kisie Jabin, had a cause to complain that it looks like it's very difficult to fight corruption in Ghana. So what do you generally think about these matters, and how would you use your office as a Supreme Court Justice to address some of these matters?
Thank you, Mr. Chairman. I believe your question was seeking to elicit my opinion about whether gifts can transform into bribery. I think my first answer to that is that it depends on the motive behind the giver of the gift. I think that our cultural settings is such that when somebody does something for you, even though you don't occupy any position in which you can maybe help the person or influence a decision, our cultural setting requires that the person the next morning should call you and thank you. Some people don't just call you to thank you, they want to follow it up and raise into the realms of bribery. But then there are some situations where somebody will present you with a gift, but you know that this gift is meant to influence me to do this or that. I think that we all have our ways of assessing these things, and it's a subjective thing, based on how based on the circumstances. You know that this thing is not just a gift. It's not just something to say thank you to you. It's giving it to me for a purpose, and you know it. If you accept that thing under those circumstances, you know yourself that you are committing corruption. Now, about the perception that the whole country is corrupt, it is an unfortunate perception. When you read some of these Afrobarometer reports, it's like everybody is corrupt. And if it is true, it is very worrying as a country, and it must be addressed. Thank you.
Yeah, thank you very much. Congratulations.
Okay. Yes. Did you raise your hand? I saw her hand. Yes. But okay, you're from the majority, so you may proceed.
Thank you, Mr. Chairman. Chairman, I want to find out from the nominee what motivated him to join the bench, because I have known him way back in the 90s when he was practicing in Tema. He was a very successful private practitioner. So I want to find out what motivated him to decide to join the bench.
Thank you, Mr. Chairman. My answer to this is that it is actually in pursuit, first of all, of a career path. It's something that even when I was at the Faculty of Law, I determined or dreamt about that one day, after I practiced for a certain number of years, I would want to become a judge. So it is a career path that I'm pursuing. But more importantly, I think that after having practiced for like 35 years, it got to a stage where the practice did not mean a lot to me again. The money that I was earning from the practice did not. I thought that there was something more fulfilling to accomplish in life. And I felt like sometimes I compare this feeling to the feeling or the urges that people get when they say they are called by God to be pastors. I think that is the same feeling. I got the urge that I should serve. It was time for me to give back to society, the society that had made me who I am. I should give back to that society. So these were some of the considerations. And then my peers were also encouraging me that, look, you can do very well as a judge. And they encouraged me. And that's how come they nominated my name. Before I got to the court, I didn't even know my name had been nominated. It was when somebody called me and said, your name has been nominated to be a Court of Appeal judge. And when it came up, I couldn't refuse it. Thank you.
Chairman, thank you very much. And I can only congratulate the nominee and wish him the very best in his endeavors. Thank you.
All right. Thank you.
Yes.
Thank you very much, Mr. Chair, for the opportunity. Congratulations, my Lord.
Thank you.
Before you came, your colleague was asked a lot of questions about delays in court. I excuse some of them because, you see, I know there isn't much a judge can do apart from what you do to expedite the hearing of cases. The courts are choked. What will be your take in your own small way? What can you do in the area of ADR to help reduce the cases in court?
Thank you, Honorable Chair. I have said that with the little statistics that I have seen, it appears that about 50 or 60% of cases can be settled amicably before they proceed to trial. And these are studies that have been made by professionals, so I don't have cause to dispute it. So ADR has a lot of advantages. And I'm glad that the judiciary right now, we have something called ADR Week, that we are, as it were, publicizing the advantages of ADR. It comes on the media and everything. I think it's a very good thing. And we are doing it. But to supplement the ADR, this is something that the judiciary is also doing. And I will urge that be consolidated. That we have this idea where apart from the pre-trial courts, pre-trial sessions and commercial courts, and the effect of CIY 133, which requires a judge to inquire of the parties whether they want to. I think we can take it a little step further, where we make pre-trial conferences or settlement conferences a major part of every case. And not just make it like a mouth, something that we are using paid service to it. We will structure it in a way that we will put timelines on it. And we would ensure that the litigants and the lawyers take it very seriously. But there are mechanisms for us to ensure that if we are able to do this, to complement the ADR, to complement the CI 133, I think that eventually we may end up with about 80% of our cases not going to trial. Because there are so many advantages in this. So that is what I'll be urging, that we should bring back pre-trial settlement conferences maybe not bring back, but consolidate it in such a way that it will have maximized benefits for our justice delivery system. Thank you.
I'm happy the Chief Justice is here. I'm sure she may put you on the schedule to do that so that we use ADR. If you have people who have practiced 45 years, it's not very interesting to say that you are also 19 years. But I think that after practicing for only 19 years, some of the cases could be settled with I am sorry. In matrimonial courts, sometimes all the woman is asking for is an apology. And so I think that if you take the men, they are the ones causing the problem. Where will they get the sorry from? So I think that if we take it seriously, it will go a long way into helping us. So I'm happy you like it. My next question. The person creating the problem cannot get an apology, so let me proceed. My next one will be, if you are asked to suggest some reforms in legal education, what will be some of your take?
Thank you.
I think the same question has been asked in some other way. Is that right? Legal education. Sorry, legal reform.
I think that the problems that have saddled the issue of legal education in the past has been the issue of infrastructure and absence of facilities to host the increasingly large number of people who want to practice as lawyers. So if as a nation we want to really enhance legal education, that would be my first point of call. How do we enhance the infrastructure, the logistics, the resources to be able to train lawyers? And then number two, I think that we should also have a focus of not just producing the lawyers, but producing a certain standard of lawyers that maybe 10, 20 years will not look back and say, why were we only interested in the quantity but not in the quality? So if I have the opportunity to say anything, that is what I will say. Thank you.
That will be all. I like the answers.
All right. Thank you very much. Okay. I'll give one each. Hey, no, Eric hasn't spoken, so yeah, go.
Thank you very much, Chairman. Chairman. Today there have been a lot of friendly questions. Very friendly questions. And I'm going to continue with the friendly questions. Mr. Speaker, in April 2022, the U.S. Department of State issued their 2021 annual country report on human rights practices, which indicated that the judiciary in Ghana is corrupt, with officials, including judges, taking money to interfere in justice delivery. Before the U.S. State Department reports, an Afro-Barometer report by the Ghana Center for Democratic Development (CDD) showed that 85% of Ghanaians perceive judges and magistrates as corrupt. My question is corruption within the judiciary perceived or real?
All right. Is that okay? Yes. Please answer.
Okay. Thank you, Mr. Chairman. I think that as an honorable member started is the premise of this question with that it is a perception and not a reality. Now, the way I want to approach this question is that the perception appears to be fueled by a number of factors. And some of the factors appear to be the fact that a lot of people don't understand the way the law works. That is the simple truth. You see, law is very difficult. And people sometimes they lose cases not because the judge is corrupt, but maybe because of bad lawyering, or because they did not understand the procedure. I remember when I was in practice with Mr. Chairman's campaign, if I can say this. When I was in practice, I was consulted by vessel owners outside the country who wanted me to arrest a vessel in Ghana based on a claim that they thought they had. When they brought the documentation, I advised them that this claim that you have can be pursued in England. But in Ghana, our laws will not allow you to go to court and pursue this particular claim based on the way you framed it. I didn't hear from them. After 2 weeks, they called me, they sent me a message that they contacted a first-class maritime lawyer who has assured them that the claim can be pursued in Ghana. So I left the matter. After some time, I heard that claim eventually ended up at the Supreme Court. And the Supreme Court struck out the claim that it was incompetent because it could not be pursued in Ghana. I happened to meet this one of the white men at an occasion somewhere. And I asked, what happened to your case? And so don't mind your corrupt judges. The lawyer went and gave them money. And I was shocked. I was shocked because the claim was bad. And I was shocked that he could say that some lawyer went to give 5 Supreme Court judges bribe in order to do this. I was shocked. So there's always this idea that people don't understand why they lose cases. And beyond that, there's an industry that legs around the judiciary. People have made it their lifestyle, where they will come and say that give me money, let me go to and give it to the judge. It is a reality. We can't dispute that. It is their lifestyle, their livelihood. So it makes this whole idea of tagging the judiciary being a corrupt institution very worrisome. I've been on the bench for 4 years, and I can say for a fact that the judges that I have come into contact with, in Cape Coast I sat with them, in Accra I sat with them, presently I'm sitting in Kumasi I sat with them. They are some of the finest people I've ever met in my life. And I'm not saying this to make up for any judges. They are some of the finest, and what I've realized interacting with these judges is that they hold their reputation to heart. Their reputation means a lot to them. So sometimes I ask myself, so these are the people that people accuse of being corrupt. Having said that, I will not dispute the fact that there may be some bad notes. There may be some bad notes who may probably be ruining the reputation of the judiciary. How do we deal with these bad notes? There are remedies that the judiciary is already pursuing vigorously, especially, and I can say this, under the flagship of our current Chief Justice, whom everybody knows is a fierce fighter against corruption. I'm not saying this because she's here. Everybody knows she's a fierce fighter against corruption. And I can consolidate. We have a complaints unit can consolidate that we are training people. But most importantly, what gladdens my heart most with what the Chief Justice is doing now is that we are lifting the veil from the judiciary. I'm assuring you, like 10 years, this corruption thing will change. Because if we continue doing this, getting people to come on the air and tell the public what we are doing, the number of cases we are handling, how we are struggling to administer justice, and how we are making justice work in Ghana. Because we don't have a mouthpiece in the media space. If we are able to do this in 10 years, the narrative will change. And I always say that it's better to say that the glass is half full than to say it's half empty. And we also have to be mindful of the fact that people out there are listening. The other time I was talking to somebody who was talking about Rwanda. How Rwanda investors are flocking to Rwanda. And I asked him, what does he think is it? Because now people think that the judiciary in Rwanda is very straight. So what if we in Ghana, we also start changing our narrative? I'm not saying that the thing is there, we should deny that it's there. But if the thing is not there, and we are accusing ourselves, and we thought about the damage that we are doing to ourselves, rather than looking at the positive side, and maybe, as it were, making it the positive side shine more and see how much investors you can, how much you can attract people to see us in a more positive light. These are reports that are emanating from there. Where do they get their complaints from? They get it from our own people, from our own perceptions. What if the narrative has changed? And now they say that Ghana judiciary is now performing very well. We have a system now that is working. What can happen? So that is my answer. Thank you.
All right. After Derek, you have one more.
One more. I wanted to ask a follow-up before the...
No, go to one more. I want to regulate the time a little more.
Mr. Chairman, one more. No, I'm asking this because some friends had the opportunity to ask 2-3. And I'm a member of the committee.
I know.
Of good standing. And that's why I'm asking.
Go to your second question.
Thank you very much, Speaker. From the answer you gave, clearly, if the image of the judiciary is good, it can, together with other factors, induce investment into this country. So what specific measures do you propose for implementation to redeem the image of the judiciary in Ghana?
Thank you, Mr. Chairman. I think I indicated that the current CD has started a program where we are now stepping forward to actually lift the veil. Because when you realize that anything that is shrouded in secrecy breeds suspicion. And people think, too many people think that the judiciary is some closed sect. Some people think that we are occult. So when we die, they bury us upside down. No, seriously, some people think that face down. Because they don't know who we really are. So if there's one thing that I think will help us more, it's what we have started doing. And like I said, one of our best writers was on TV the other time. And after speaking about what the judiciary does, I just fell in love with the judiciary. I fell in love with the judiciary. So if we continue doing that, giving us a space and a mouthpiece within that space, I think that gradually the perception will change. Thank you.
Mr. Chairman, my last question. Mr. Chairman, according to the World Justice Project 2019, Ghana's justice system was adjudged African sees best in the 2019 Rule of Law Index, dropping from the first position in 2018. The country is a signatory to the African Charter of Human Rights, Human and People's Rights, and the Maputo Protocol, both of which oblige the states to ensure that citizens have access to justice delivery. The Speaker again, under Article 14 of the 1992 Constitution, access to justice is safeguarded for citizens of our country. Nonetheless, the judicial sector is burdened with challenges that threaten the efficient delivery of justice. I want to know from the nominee what proposals he has in mind for consideration to ensure affordability, proximity, and comprehensibility of justice to all Ghanaians.
Thank you, Honorable Chair. In essence, your question invites me to speak on the issue of affordability to justice. Yes, I'm taking them one by one, yes. Affordability to justice. I believe that, like you rightfully said, the access to justice is there. The Constitution guarantees it. That's one of our basic pillars of our rule of law. Now, on the issue of affordability, I think that the court system is structured in such a way that we have a small claims court, where if you have a small claim, maybe at the district court, you can go there where the procedure is very, very informal. It's very informal. You can go there and pursue your claim and to the hilt. Issue of affordability is also there, where we have court-assisted ADR. It's also one of the major improvements that the judiciary is pursuing, and it's also helping a lot of people. And then number 3, we have legal aid, which is guaranteed also under the Constitution, and a lot of people are also taking advantage of that. Now, when it comes to proximity, I think you are talking about physical proximity. Yes, physical proximity. I know for a fact that there's a program now. The last time I heard, we were building like 200 courts. 200 courts, in addition to what we already have. So if you're able to do this, access and proximity, bringing the courts to the doorstep, to answer the question. Thank you.
Okay. All right, Zora.
Thank you, Mr. Chairman. Good afternoon and congratulations.
Thank you, Honorable Member.
Mr. Nominee, you have a very pleasant and relaxing personality.
Honorable Member. Thank you.
And I'm wondering, is that how you are when you are in court? And also when you are before your students, because I can see on your CV that you're also teaching at the School of Law.
You know, courtroom psychology is something that you learn as you practice. And you learn the way you present yourself, the way you articulate your ideas. It's something that you learn. And I believe that, yes, it's something that I've acquired over the years. Thank you.
It's good to know, Mr. Chairman, especially in these times where we are all struggling with the hardships, working around with long, drawn faces. At least there is hope that there are some people around like you, that when we come encounter you, I mean, we have a sense of relief. We are happy to be with you today. I just have one question, and my question is, I want to find out from you, in the event that you get the nod of this committee, what will be your approach to cases involving intersectional issues such as gender, minorities, vulnerable people, especially within the context of what we see as a failure of the law to protect minorities and people of vulnerability? Thank you.
Thank you, Honorable Chair. I think that I can only answer this question by reference to the Constitution. What the Constitution requires of me as a judge. Article 17, I think, is one of the basic pillars of our fundamental human rights, which frowns on discrimination. And if thankfully given a nod by this august committee, I would enforce those provisions to the hilt and ensure that there is no breach of that constitutional provision as far as gender, balance, minorities, and vulnerable, their rights and interests are concerned. Once it falls within my scope as a lawyer, I would enforce the law, the Constitution, and the law, which requires these provisions to be enforced. That's how I would do. Thank you.
Yes. Any of you can take it there.
All right. Thank you, Mr. Chairman, for the opportunity. Congratulations, Honorable Nominee.
Thank you.
Honorable Nominee, I came across an interesting piece. Ghana's Freeport Act, 1995. A maritime legislation drafting project submitted in partial fulfillment of the requirement for the award of the degree of Master of Law at the IMO International Maritime Law Institute, Malta, May 1995. Supervisor Professor P.K., forgive me, I can't mention the other name, Mukeji, yes, and it was submitted by you.
Can you remind me again the title?
The title is a Maritime Legislation Drafting Project, submitted in partial fulfillment of the requirement for, okay, so Ghana Freeport Act.
Okay.
Ghana Freeport Act, 1995. I found it interesting because I've been wondering. I use the Terminal 2 a lot. In fact, almost every weekend, I go to my constituency. And I think it is larger than the purpose it is serving as a domestic terminal. And I've heard of Buankra that is not taking off, despite attempts by previous governments and now. And so reading through this piece of academic work that you did, I started wondering if there's a way we can take advantage of that as a country and establish some of these ports as free ports that can serve purposes beyond the purpose that they are serving now. And if an agency is required, I mean, based on the experience with which you wrote this piece and our situation, how do you think it can help our ports expansion in the country and utilization of those that are already in existence?
Thank you, Mr. Chair. I wrote this piece at the time that Ghana had not started the Freeport project. The Ghana Ports and Harbours Authority, where I was employed, was like an ubiquitous organization. It was doing stevedoring, it was doing shore handling, it was doing cargo handling, and there were a lot of deficiencies. We were running into serious debt. So we thought that the whole world was shifting to a free port system, where the port itself will be like a landlord port, without getting itself involved in private operations. So the whole idea was a shift from government involving itself in private port operations. And that was the direction that we took. And I can say for a fact that since, I think 1997, 1998, the government has gradually shifted from the system whereby it used to be the ubiquitous type of port operator, and has now delegated most of its private operations to private organizations. And I think it is working to the betterment of the country. So I agree with Honorable Chair that it is something that we have started and we should consolidate it. Maybe we have not reached the perfection yet because of maybe one or two bureaucratic problems, but it's something that we should perfect it and make the Ghana Ports and Harbours only a landlord port, where we would only maintain the physical structures and maybe receive rent for vessels that will come and dock at the port. But when it comes to private operations, stevedoring, shore handling, storage facilities, containerization especially, we leave it out to the private sector to take up. And if we can replicate this private port experience in all the other smaller ports, I think we'll be making much more, it will be much more beneficial to us as a country than for the government to continue getting itself involved in some of these activities. Thank you.
Mr. Chairman, this is a follow-up. Do we have a Free Port Act in Ghana? I didn't check that, but I doubt.
I will have to check, but I knew that there was a bill that was presented to Parliament that changed the character of the, was supposed to change the character of the GPHA as a landlord, as a private operator to that of a landlord. But I'll have to check, Mr. Chairman.
Okay. Maybe I will find time and discuss that piece of academic work that you did, just for education and perhaps contribution to other such discussions later. Because I think that's worth following up. I'm not too satisfied with the answer, but I will proceed. And maybe when we have a conversation later, I can come clearer and perhaps I'll understand you better. But you talked about your work with the Ghana Ports and Harbors Authority. You also have listed it on page 3 of your CV. Yeah. I want to know how your working relationship with the Ports and Harbors Authority came to an end.
Thank you, Mr. Chairman. I resigned from the authority in the year 2002. And the immediate cause for my resignation was that the port had then decided that it was no longer going to involve itself in private operations. And so there was a redundancy exercise where there was a rearrangement of the departments. Now, the lawyers in the legal departments were reassigned. I was reassigned to go and head the human resource department at the port of Takoradi. And my immediate senior was reassigned to go and head the human resource department at the port of Tema. So I had to weigh my options. Do I want to pursue a career in human resource, or I wanted to pursue a career in maritime law? I advised myself that I wanted to pursue a career in maritime law. So I resigned and set up my chambers, Beulah Chambers, in 2002, from whence I operated till the year 2019. Thank you.
You were not dismissed and you didn't sue the authority?
No, I was not dismissed. I sued the authority because I thought the reassignment from a legal department to the administrative department was a change in my line of work that was to my detriment. So I had conversation with the then most senior lawyer in Tema, Mr. Jules Mensah of blessed memory, and he was very convinced in his mind that this is the matter that we should pursue at the court, just to test the law, whether the reassignment amounted to a diminution in the terms and conditions of my employment. So we took suit, and we won at the High Court in Tema. But fortunately, unfortunately, the Court of Appeal thought that they took a different view of the facts and overturned the decision of the High Court. So that is what happened. By that time, I had resigned from the authority.
But I was going through the reliefs that your case sought, and relief number 1 was damages for constructive wrongful dismissal.
Yes. So if you're a lawyer, you realize that dismissal does not have to be like I've dismissed you. If there's a change in the terms of your employment, which you think it is to your detriment, you can term it as a constructive dismissal. So that is what we termed the reassignment to be. It was the way we termed it, that we thought that by law it was a constructive dismissal. And the High Court, like I've said, agreed with us.
And we also educate our core central, our vision, even with Decan, is educating creative leaders to transform Africa. So everything we do here is in the line of education, is in the line of challenging thought, is in the line of educating people, and is in the line of celebrating ourselves as African. Because for generations, people have told our stories, people have displayed our stories, but now it's like we're taking that ownership back to own our stories, to tell them the way we tell our stories.
I see. Interesting. Thank you, Paul, and thanks for.
Now, apart from the president's who appointed judges. We have also the issue of politically active persons who have been appointed by President.
Also, make sure that casting image and sign with you.
Liabgam Simila Ben Shadan Pierna Kamale, Carmel Bukata, Namana Zaman Nutambo, Zanjanda Liabgam Simple, now on this so.
Daga cikin muhimman rawa na azo a gani da Hausawa suka taka a cikin wannan ƙasa shine kafa zangonnai da suka zama gimshiki na cibiyoyin kasuwanci da fatauci. Ko shakka babu, shi ke karfafa ingantacciyar tattalin arziki da kuma karfafa al'adun gargajiya.
Wọ́n ke abuna gbogbe ke bi ehian wa. Ke ofian wa ke okobi abawe ni awele ka bu yan ni sanagbu abagbule. Ke vitamin A un ni sanahagbe ke sani ahale.
Jujogberudo kokodi yakatoi. Enyai ba angau hana mona chishipo iha chirodovania. Watan atrangau azunububuwe.
Sukuu no mo yeko buke adwunu. No ma na bi sukuu no le bara.